Let's bring in CNN legal analyst Shane Wu. He's also a defense attorney and former federal prosecutor. Shane, welcome back.
Good morning.
I want to get to some of the specific legal questions, but first, this response to what Representative Kildee says. Can you imagine this dragging on until February?
I can actually, Victor. You know, procedurally and legally, there really aren't any guardrails here about how long it could go on for or what direction it could veer in. So, you know, there are a lot of political speculation about whether it would hurt or help the Democrats to drag it on. My view is actually here it probably helps them to drag it on politically because it keeps more pressure on the president's defenders.
Helps Democrats.
House Democrats, yes.
Okay. So there is also, if this goes on until February, there is a school of thought that's expressed by Noah Feldman. We've discussed this in the past. That says, well, until the articles are taken over to the Senate, the president really has not been impeached. And Jonathan Turley, he's weighed in on this now. The interesting element here, Shane, is that Noah Feldman was a Democrat witness during the impeachment hearings during the House. And we heard from Jonathan Turley from the Republicans. Where do you weigh in here? Has the president been impeached by virtue of the vote in the House? Or is impeachment a process that requires now the second half of those House managers taking the articles to the Senate?
Well, I'd like to assure our viewers that the president has been impeached, in my view. I think this debate is a little bit like that old freshman college philosophy debate. If a tree falls in the forest, no one's there to hear it, doesn't make any noise. There is definitely someone there to hear it, first of all, and it's on the record. I mean, the Constitution only talks about the House having the sole power to impeach and the Senate having the power to try the case. There's nothing about whether the physical delivery or transmission of the articles triggers the impeachment, and there's been a vote, there are articles of impeachment. So I think that's mostly an academic exercise at this point. And of course, interestingly, there's a little bit of a role reversal there with Turley, who had been testifying to Republicans, saying this is nonsense, he definitely has been impeached.
All right, let's go to the Senate now. And you remind us that, I mean, look, first, the president is likely to be acquitted here. There is no evidence that 67 senators will vote to remove the president from office. And likely the president will, throughout the campaign season, say that he was exonerated. But you remind us that acquittal is not exoneration, especially in a political context.
That's exactly right, Victor. Acquittal in any kind of trial is never an exoneration. And if we look at the criminal analogy here, it's important for us all to remember that when a jury returns a verdict in a criminal case, they don't ever find the defendant innocent. They find the defendant not guilty. And what they're looking at there is whether, in their view, the evidence proved the charged conduct beyond a reasonable doubt. So that's a flawed analogy when you look at an impeachment trial, because they're not really looking at whether the evidence proved the conduct charged in the articles of impeachment. They're deciding whether he or she should be removed for that conduct. And that's a whole different question. So if they vote not to remove him, it really has nothing to do with the underlying conduct. So if we look at the example of President Clinton, who was not removed, nobody in hindsight thinks that the fact that he was not removed from office means that he did not have an affair with an intern and did not lie under oath. And that's the crucial difference when we talk about impeachment and criminal trials. A lot of analogies being made, but this is one of the biggest differences, and this is the significance of it being a legal proceeding, but in a political form, because that's the partisan nature of it. That's the politics. They're making a political decision whether this conduct warrants removal of the president from office.
Let's talk now about Chief Justice John Roberts. He'll preside over the trial. And we know that he has worked to keep the court from seeming political. But if this impasse continues, and depending upon what the rule agreement is, or if there is no agreement, and once McConnell gets the articles, he moves on without some handshake with Schumer, can he maintain that? And how much of his ability to do that is based on what we're seeing right now?
I think he can maintain it. I think Roberts, like most Chief Justices, are very focused on the integrity and the reputation of the institution. It's interesting, the setup there, because McConnell, of course, is also focused on the integrity and maintenance of the Senate as an institution. So Roberts is not going to want to look like he can be accused of partisan politics, being too involved here. So I think he's going to mostly try to defer to the senators, make them vote on their own proceedings. I mean, again, if we look historically at what Chief Justice Rehnquist did during the Clinton trial, he basically did very little. I think he borrowed a quote from Gilbert and Sullivan saying that he did very little, but he did it very well. And I think that Chief Justice Roberts is certainly going to try and stay out of the fray.
Yeah, of course, Schumer and McConnell have to come up with more than a handshake agreement. They have to come up with the rules and the procedures of all of this. But if it's acrimonious, will they force Chief Justice Roberts to make some difficult calls? Shan Wu, thanks for helping us break it down.
Good to see you, Victor.
Likewise.